Any mention? Item, item number on, section 17 of 2024.
I am before this court for an admission under Order 41, Rule 11. Being second appeal, my lordship, unless a substantial question of law is not formulated, the Honorable Single Judge cannot take the appeal on it.
Yes, let us see what is the issue.
May I please?
Please, yes.
What has happened? I am an encroacher of a government revenue land. There is no dispute in this fact. In the written statement, they have admitted it.
Who is you were the plaintiff?
I am the plaintiff.
Respondent is?
The authorities. The land owned by the authorities under the local regulation, regulation 38. My suit was simpliciter for claiming possessory right.
Where is the prayer in the suit?
I am giving the copy of the okay. It was not my case claiming right based on adverse possession. I never claimed it. I said you evict me with due process of law, but till such time a decree of permanent injunction has to be given and a possessory right has to be declared.
No, but you seek the relief B is you seek their right to be extinguished.
No, right, because the property stands in their name under the local regulation. If I am possessing and I am not being evicted within the period of
extinguishment of their rights and a permanent injunction.
My lord, but it was not a suit for adverse possession. The trial court went on the premises that as if it's a suit for.
But your from the prayer, it appears your claim is not based on anything but possession.
Absolutely, absolutely.
So then what is it?
But there are two things. If I claim is a possessory right, the sine qua non would be I have to show my possession. If I claims right based on my possession.
No, but your prayer B.
My lord.
Your prayer B is in a way ousting the total claim or the whatever right the state may be having. You seek extinguishment of their rights.
But there is
right, title, interest, everything. So what remains with the state?
But there is no adjudication made by the trial court, my lord. There is no adjudication. So this has been prayed for. Lord would see the trial court's judgment. Lord,
no, first we are on the maintainability of the prayer.
Lord.
Whether such a right you can claim,
Lord.
Having regard to the provisions contained in the LR and LR and other
it can be
survey,
my lord.
Tenancy.
My lord.
Yes, let us see.
My lord.
Extinguishment of the state's right altogether. This is a prayer.
No.
Let us see under which provision you can claim that. Where is the provision for extinguishment of claim of the state?
53, my lord, regulation 162 of the book. The first part of the book, regulation.
Page 162.
133, page 33. And regulation is 162. My lord would find at the right hand side. Extinguishment of tenancy.
Yes.
My lord, the interest of a tenant in his holding.
This is a tenant's extinguishment of tenant's right, not the government's right. A tenant is a government's tenant, not it will not apply to the government.
The suit land as of now recorded in the name of government as a tenant. As a tenant.
Cannot be, sir. Cannot be. The government is not the tenant. It must have vested in the government. The government will give tenancy rights. Government cannot be a tenant.
But this was not adjudicated by the court.
So therefore, it's a second appeal.
Hello.
And you have, perhaps it has been affirmed by the appellate court.
Affirmation.
Then what is the?
What I pray, Lordship, the trial court went on a premises.
At the very outset, on seeing the prayer, it struck us that it could not be. So therefore.
So far as my possessory right is concerned, my lord.
Yes.
My possessory right. They can have every right to evict me.
That is not the issue. The issue is whether your suit was to be decreed in your favor or not, based on the prayer made by you and the provisions contained in the law which governs the status of the parties. A prima facie from bare perusal of 162, it does not come in aid of your prayer. It says, it talks about extinguishment of rights of a tenant. A tenancy must have been defined. Where is the definition of tenancy? Yes.
Find the definition of tenant. at page 3, sub-rule 29 of rule, that's clause 2, page 3.
See. The person by whom the rent is payable. Cannot be. So clear as daylight, sir.
But this was not never went on trial on this issue, Lord. There was no adjudication by either by the trial court or by the first appellate court. The entire,
So what is the question of law?
my question is, Lord, I could not have been evicted without due process of law. The trial court, what trial
Who
court?
has proceeded for eviction? You are claiming a declaration of extinguishment of rights. Where is the question?
Primary relief.
Which is the order? Which is the order of eviction which you challenged?
No, eviction was passed.
Then where is the question of eviction?
Kindly appreciate. It's purely a case of dispossession without due process of law.
Where is that case?
Not-
We have not sought any prayer
Yes, prayer.
of quashing of any order purporting to evict you in any way.
So there cannot be any order, lawsuit. Threat of dispossession was given. I filed the suit in the year
Yes.
2012. You know, kindly appreciate this.
Let us see what you have said.
Lord would see. Paragraph 9 of the plaint. This gave me a cause of action to maintain the suit. On 26/4/2012, the subordinate revenue officer attached with the office of defendant number 3 in usual undesired manner entered into the suit land and threatened the plaintiff that in the event plaintiff does not vacate the suit land and dismantle the standing dwelling house, then and in that event, the said defendant would cause removal of plaintiff from the suit land without due process of law. It was also threatened that those revenue officers would take law in their own hands in order to give effect to their nefarious acts. Plaintiff therefore filed the present suit before this court claiming appropriate relief. My prayer one, Lord, would see you throw me out of the suit land, but invoking the. My prayer, the first prayer may kindly be in prayer, Lord.
Yes.
I say I'm in possession, you admit in the written statement. You initiated an appropriate proceeding. What is the appropriate proceeding under the local regulation? But it's 202. Lord would see. It's a government revenue land. Set the proceeding in motion.
Where is the WS file?
My lord.
Reply to your paragraph 9. There is no threat. There is no such threat. You read the paragraph 9.
Yes,
The WS. You were erecting permanent structures, they stopped.
This is in the form of a threat only, my lord. I'm occupying, threat have a, my lord, no, there are different facets of a threat. Simply going to the suit land and asking me vacate. If I'm doing substantial work,
They are saying no question of vacation. They say
Therefore, he
don't
stopped
make any
from-
construction.
my lord,
So
I'm residing there with my family members, not what I pray, my lord. Can you appreciate one thing, my lord? In these islands, lordship, the encroachers are not the aliens. They have certain rights which are recognized under the local regulation. It's not no schemes of regularization. There are several schemes included. It's not that we are, if I encroach in a government revenue, I'm not entitled to get any benefit. You do whatever the authority wants can do. But set the proceeding in motion. What is the proceeding, my lord? Regulation 202.
the suit cannot be used as a means to regularize the land which you are providing. For that, there is a specified procedure. Which you could have resorted to and the authorities could have examined under the 2-3 schemes which we have had the option
Yes,
of
ma'am.
seeing
Yes,
till now.
yes.
The case here is encroachment. You have started to make some construction. They come and said, don't do it.
My lord.
Then you say, no, this is my land. You come to the court, declare it as my land, extinguish their rights.
No.
Now, in that circumstance, whether the court should have passed a decree in your favor or not, that's the only.
Sir, I have not claimed any right. I cannot claim it also.
Sir, what else is a right when you say extinguishment of the right of the defendant means that the land is not theirs?
But the possessory right, the primary
That's
prayer
not the
in
issue.
form of
That's not, there's
possessory
no
right.
question of primary right. You had the option of foregoing certain prayers in this suit. You did not.
But
You have gone whole with the entire issue up to the appellate court. Have you forgone any of the prayers either before the
So
trial?
I paid to Lordship as regard extreme, I never led any evidence, no argument
That
was
is not a way of foregoing any prayer.
CPC.
That is not the way. So therefore we are asking. But you never did that. You are pressing the entire claim.
My point is, kindly appreciate. Kindly
Yes.
appreciate one.
What is your submission? Let
My
us see.
submission is Lordship 202 ought to have been invoked, which the authority failed. I filed the suit. It will not
So
look.
where is this submission in the before the trial court? Let us
The
see.
trial court went in a different premises. That's the point, my lord.
The trial court, what was argued by you? Let us read the order.
Trial court said it is
You cannot.
position.
Let us see
My lord.
what you have argued before the trial.
May I place the trial court?
We'll read. Yes. Provision for execution of a convenience.
Execution of convenience.
Yes.
Under the regulation, it's based on convenience, mutations are only be done. There's no provision for executing a convenience. In terms of the Transfer of Property Act and Registration Act, a conveyance in these islands are being done. When it comes for mutation, it's being done under Regulation 84/85 of the local regulation. And there is one more mode, Lordship, authority can issue a license. It's also a conveyance in the stricto sensu, so far as regulation is concerned. Government land is conferred to.
Authority, you are not recognizing the authority. You say they have no right, title, and interest. The court should declare an extinguishment of the right, title, and interest. Yes. We have read it.
My lord, it seems, my lord, I have already disclosed what my lord is going to do. So I want to, because this is my case all about. My point is, my lordship, only on a solitary substantial question where it can be, my lord. Appeal can be admitted. My lord, as not, it's a settled law. It's no more a residentia. You want to throw me in due process of law, but not in the way it has been done. And if it's a case of
What way it has been done? Where is the question of throwing you out?
no,
The
they have
factual
admitted.
basis for such a submission is not there in
In the
the
written
issue
statement,
made out based on the pleading of the parties. There is no such issue. They have not said that we are throwing him out. They said don't construct. Obviously, after going through, we have also learned something from reading reading the judgment. 202(8). It is quite obvious now. The whole purpose of filing
Nothing
this
more to be
suit.
added. Nothing more to be added. Lord, may I say one thing?
Yes, please.
Instead of the order which my lord is proposed to pass today, can it be passed tomorrow? Today, because no, this is what my humble.
No, we'll pass
As-
the, we have heard the parties,
as-
heard the parties.
Match 3 of 125.
This has to be taken up in the next circuit. Service, they all reside having office at North and Middle Nama. It will take time. Let come in the next circuit.
Is there any order earlier for?
No, it's coming for the first time. It's coming for the first time.
226.
To appeal under against 226.
Effective 2 of 124 with can 3 of 113.
Not today.
Effective 1 of 2022.
Served already. Not today.
5, effective 5 of 2023.
If you are appearing, you may give your appearance to be recorded. Yes. Take the appearance of the party who is appearing. Yes.
Item 5, effective 5 of 2023.
Next. Call the next.
Item 6, WBCP. We are training for the respondent.
No.
Challenging of the writ petition challenging the order passed by the circular. Eliminating the party to appeal.
Appellate authority in respect of a proceeding.
The appeal was also filed. So the CAT has said,
No, it arises out of disciplinary proceeding.
yes, sir.
So appellate remedy has not been exhausted.
Oh, but it's as of the date of the impugned order.
Anyway, so in view of your resolution, not today, let's see.
Anyway, they are not there any order.
Let's go. Tomorrow, whatever.
He mentioning not in the list. Can you mention in the item number on WPA 507 of 2024?
I am appearing for the respondent, my lord.
Your appearance, not today.
Right. Item number 2, WPA 8 of 2025. Item number 3, WPA 10 of 2025.
All right.
Item number 6, WPA 640 of 2024.
No, 3 to 6, all not today.
Number 7,
So I am appearing, my lord, for respondent.
Yes, none for the petitioner.
Next, we have filed opposition, my lord, in the registry and serving the.
6. We are considering 6 right now.
6. I am filing the, we have filed the opposition registry and serving the copy.
A copy of the opposition has been served on the Learned Counsel for the petitioner. After being filed in the registry, full stop, let the opposition be tagged with the records for enabling the Learned Counsel for the appellant to file its appeal.
No, read petition.
The petitioner to file his reply. Matter is adjourned. When do you want it? In the next circuit.
Value oblige, my lord.
item number 7, WPA 497 of 2024.
I am appearing for the respondent, Lordship.
None for the petitioner in presence of the respondent. Matter is stands adjourned for the day. All the cases where the respondent appears, same order.
7 to 10, Lordship.
Item number 11, WPA 300 of 2021.
Next,
Item number 12, WPA 52 of 2020.
Service was to be affected on the private respondent. हो गया service.
service has been effected. Give your appearance. In
Well.
presence of the respondents, the matter stands adjourned for the day.
Item number 13, WPA 888 of 2023.
My God.
In those orders also, don't say none appears. for the
So my lord, here my lord.
respondents. Yes. Yes,
No, मैं कुछ बोलूँगा.
Item
Yes.
13,
Please.
Madam, and for the petition. So that I would need to mention. The last 3 days I was not well. Then today I am not completely well. Even then I have come. I was today. So I just take little time to make my submission. But that's what the case is.
no, you don't want to do it today, then it can be adjourned. If you are ready, then you may proceed. If there are so many adjournments, that is why is indefinite adjournments. Yes,
All those are related. It is not intentional or deliberate or not that I am usually take a sick adjournment.
yes, proceed, let us.
Right. The petition company is an industry and applied for in industrial unit, page 30. And the draw my lord's attention to page 30. Physical position was given
In the industrial estate
in the state, Dollyganj,
in 2001.
and he has invested huge amount,
Yes.
constructed his factory and it was in operation. In a nutshell, I'll explain. This was initially for 15 years. Then that was allotment was for 15 years and thereafter page 33, there was an agreement of lease. Was there.
So from 2001 to 19, nothing happened. In 19, the lease was,
2015, thereafter,
no, 19, it is 19.
19 again fresh lease agreement was there. Initially, there was no lease agreement. There was the allotment for 15 years.
Yes.
Then after 15, one agreement was that agreement is not, I am unable to place it. This is the.
No, where is the allotment for 15 years?
I will just-
Earlier allotment for 15 years.
One minute. Madam, may come to page 29.
Yes.
Page 29. Serial number 2. Leased out for term of 15 years.
No, but that was subject to execution of agreement. So
Yes, but the-
agreement has been executed in 19 after 18 years.
No.
So for 18 years,
No,
nothing has
no,
happened.
That's the facts I must narrate.
Yes.
Kindly, patiently give me time, please.
Mhm.
So, agreements were agreed, they were not disputed.
No.
Why I am unable to produce those documents, that I am coming. I am coming because what had happened. This 2019, for 3 years, it was, lease agreement was executed. Thereafter, the petitioner got, in 2013, petitioner 13 onwards, petitioner got supply order from the civil consumer department, the civil supply and consumer affairs, and to convert the wheat to wheat flour. So that contract continued from 2013 to 2021. Then they have suddenly they have inspected my premises in my absence at night 10 a.m. They have seized maximum document, and thereafter they have terminated my contract. That contract, not this lease. That contract was terminated, which is at. I'm just coming. That is not for the industrial unit. These supply orders are page 45. Kindly come, hello, to page 45.
You have challenged the notice.
No, I'm coming one by one. Today, kindly give me patiently hear me. What had happened after this?
Whatever may have happened, you have challenged the notice.
No,
Why are you not appearing in the proceedings?
I'm coming directly to that. What
Yes,
had
come to
happened?
that.
What I'm unable to place those many documents because they are seized by the
That's
police.
not the point. The point is you are just required to appear pursuant to a
For that-
notice.
For that, I'm coming to directly page 54.
You go and appear.
Kindly,
They will consider whatever you have to
Madam,
say.
kindly, I'll let me complete my submission. Allow me, please.
No,
Page 54.
sir, you have raised an issue challenging a notice. That is the only issue arising for consideration.
For that, I'm coming.
Nothing else is arising for
For that
consideration.
I'm coming.
Why the court should interfere at the notice stage? That is all that you have to say.
For that, I'm coming.
Yes,
Page 54.
yes,
I want to draw my lord's attention to page 54.
yes.
This is an eviction case notice which was received. This is dated 30/6/2023.
Yes.
Because they have cancelled me without giving me any so-called notice, with
Yes.
no the notice was served, no
Yes.
cancellation notice was served of the lease agreement.
Yes.
Thereafter, they initiated
That
this.
is what you have to tell them.
Uh,
When you appear, you have to tell them that, look, you have done this without due process. They will consider, that's not for the court to consider.
Coming to the opposition, and
Yes.
after that, this notice to appear on 27/7/2023.
Yes.
This notice. Then
Series of notices, up till August 23, so many dates fixed.
my lord,
And the last
my
notice,
lord,
all these
my lord,
notices, you are
because-
telling what is it?
because of the police case and the
That
termination.
is not the issue before this court. The issue is only whether we are to interfere at the stage of notice or not. That is the only issue.
His factory was closed.
That is not the issue here.
Now I'm coming, my lord.
Yes.
This notice I have appeared.
When did you appear?
Page 56.
Yes,
Page 56.
yes. No, this is not appearance. This is filing of a,
I filed a petition.
this is a petition. You are not appearing. You have just filed a petition.
Kindly, that the
You go,
petition.
they will serve all the copies to you,
No.
whatever is required.
No, that is Why I come for, I'm saying, principle of natural justice violation.
This petition you have filed for
They have no-
documents that they will give you.
That they have given documents. That's why I'm coming to the affidavits now.
Yes.
Why, whether they have served or not.
No, if they are not, we'll direct, I will direct.
They are not-
They will serve.
that-
You go and appear.
Because this show, no, what I'm telling is, this until, this, case before a state
Where is
officer.
this,
Madam,
where is this act?
Madam,
It's Act of 71, let us see.
Madam, before proceeding to that, I'm just thinking on something.
No, that is the only issue. Why should we go into the history of this?
Issue is-
Not required, public premise.
My prayer can kindly see, this proceeding will not appear. After the
Sir,
cancellation goes.
Sir,
That-
the court is asking you a simple question. Why the writ court or is to exercise jurisdiction at the stage of a notice?
Not at the notice.
That is all we are asking. I am asking you. Lord, you convince.
My prayer can kindly be seen. Prayer can kindly be seen.
Yes.
So page 26. To set this, not this show cause notice. To set show cause notice, not this notice. The show cause notice dated 24/6/22, final notice dated 21/9/22, and the cancellation notice dated 25/10/22, issued by the Assistant Director Technical Industries Department. This is my challenge.
Where is that?
That's why.
Where is that? Which page?
Page 26.
Page 26. No, where are these notices?
Notices, it's coming. That's why the affidavit of opposition, I'm just drawing my attention.
You have sought prayer quashing of certain notices.
No.
Where are the notices? Let us see. Where is it? 24/6/22. Let us see where it is.
No notice. I'm placing.
24/6/22. Where is 24?
Yeah, that is page 60. They have provided me, kindly come to page 59.
24/6/22 at page 60.
Kindly come to page 59 first, my lord, for 1 minute. These are the documents provided to me for the first time. I come to know that the cancellation and so cause notices were issued and which I have not acknowledged. I have stated before the state officer also. These are not served upon me. This is a violation of natural justice, principle of violation of natural justice. This is arbitrary action. That's why I sought for cancellation of those show cause notice and the cancellation notice. They have provided me this document as per the direction of the estate officer.
So all right, then they gave it to you.
Then
How did you respond to this show cause notice?
These show cause notices are before the estate officer I have received. I had challenged.
What is your response before the estate officer? Show us. Show the court. Now you have got it. So when you got it, what is the response you gave to the estate officer?
Then thereafter I filed this writ petition.
That is why I'm asking you, why the writ court? Neither you go before the estate officer, nor you are appearing before the notice under the Eviction Act, Public Premises Eviction Act.
Because
the writ court is sitting here to look into all these things, and the authorities are not to do anything.
This cancellation, that's why the affidavit.
Therefore, again, I am asking you, now you have got the notices. What did you write to the estate officer regarding these notices? Show. What have you said in the writ petition? If you have taken no steps, then what is to be done?
I'm telling. Kindly give me few minutes.
Nothing. You have not said a word.
Para,
Para 26, you should,
Kindly-
nothing has been said.
kindly come to para 20.
No. Come to para 25. That is where you have annexed the notices which were made available to you.
Yes.
After that, what have you done after receipt of this notice?
After
Done nothing.
because those notices are not served upon me, that's why I have before this writ court.
You can keep submitting the same thing 10 times, sir. I'm trying to understand your case. Saying the same thing repeatedly will not improve the situation. Therefore, I am asking you. You say that the cancellation was without complying with principles of natural justice. I was not even served with the notices. So I asked them, show me. Then they gave it to you. You took no steps.
Before the estate officer.
Correct. So why didn't you approach the authority that how you have cancelled this?
They have given incomplete documents also that I've stated.
So therefore, the writ court should become the estate officer.
These, by virtue of this cancellation,
Yes.
this proceeding before the estate officer arose. If this honorable court finds that the cancellation, the show cause notice are not served upon me, if the cancellation goes,
Yes.
then the automatically the proceeding before the estate officer goes.
Yes.
That is my humble submission.
All right.
Then that's why affidavit in opposition may kindly be looked into their opposition.
What have they said?
Kindly.
They will place their opposition. Don't worry. They will place their opposition.
So that in my reply, what I have said, I can say.
What have they said that you have to reply to?
No. Yes, I have given a reply. Reply is there.
What is your stand?
They
We
said
have
that
served them everything, my lord. We have annexed the proof of service also, my lord.
that I will
see.
show.
So first, kindly see para 4 of the affidavit in opposition.
Yes.
Kindly see the serial number 2, show cause notice dated 24th June 2022 was issued to the party through speed post,
Serial
which
one.
was returned with the remark door closed. Copy of speed post with AD returned by post office and show cause notice dated 24th June 2022 annex. Then my lord will see to serial number 3. Final show cause notice dated 21st September 22 annexed. Final show cause notice was received by representative of the petitioner on 23rd September 22. Copy of the acknowledgement is attached. Then my lord, serial number 4, cancellation notice dated 25th October 2022 issued by Assistant Director Technical video which decision of cancellation or allotment of the said plot by the Secretary Industries in Annex to Annexure E. Then cancellation notice dated 25th, the same notice was pasted in the factory premises on 27th October 2022, hereto marked as Annexure F. Since petitioner did not comply to the cancellation notice, did not hand over the peaceful possession of the plot, estate officer was requested to evict the premises under Public Premises Act. So my lord will see after that, so far as the documents are concerned, paragraph 5. Following documents were served upon writ petitioner by estate officer. Even the estate officer served
No,
these documents.
state officer did not.
Now, kindly see.
This is the way. Yes.
Sorry.
Then my lord, serial number 1, letter notice dated 20th March 23. Since addressee was not found at designated location, notice was pasted on the door. Then letter notice dated 17th April 23. Since door was found locked, notice was pasted. Then letter
So
notice
this, all right, that you have said that sufficient.
in any event, now he has all the documents. He can appear before the estate officer if he's
No,
saying.
but is there any authority where he can assail the cancellation of allotment?
No, that my lord, if he wants, I can't advise him, but my lord, there are
No,
provisions.
we are saying whether the statute or the rule provides any forum where we can
My lord,
accept.
if the agreement, if I recall, my lord, the agreement has an arbitration clause, my lord. Those
Okay.
remedies he has to undertake, my lord.
No, have you said anything about
Yes,
this?
we have actually only the court had directed us to file an affidavit to show because since only issue was natural justice, whether the documents had been served or not.
No.
Affidavit on the
See,
merits of the
natural
case is
justice-
not called for.
Yeah, I'm not on merits also.
My lord.
What I am observing is he has been served with an eviction notice.
Yes, my lord.
He said eviction could have been done only after cancellation. Cancellation is not in accordance with law because it's with non-compliance of principles of nature. You say, no, we have served, but
My-
now he has all the documents anyway.
My lord.
So against the cancellation, there must be some authority. which
There is an arbitration clause in the
agreement.
Page number 38.
Page 38.
Then you have to file a petition under section 9.
Whatever legal proceedings.
We are not here to advise you.
But one thing, that cancellation remains. I said that's why I wanted to read my reply.
Yes.
My-
All right, so then I will consider whether there is valid service or not. Yes, you show the reply.
Kindly come to
As against so many evidence which they have,
page 4.
which they have annexed in their affidavit in opposition.
Yes, madam. Page 4.
What have you said?
Page 4. Page 2 of my reply. Paragraph 4. Mary.
So in paragraph 4 is the details regarding service of notice in the cancellation proceeding,
Right,
and in 5 regarding the eviction proceeding.
right.
What all documents? First is 9 December 21.
Right.
Reply should be-
These points can be taken before the estate officer also.
The petitioner, he invested huge amount there. More than 1 crore worth amount is there, building and machineries.
Where is the agreement?
Agreement. Page 38. The arbitration clause is at page 38. Starts from 33. Para 15 is the arbitration clause, that is 38.
In any case, this term has come to an end, 3 years from
From
2019 is the agreement, 5th August 2019. It was for a period of 3 years. And paragraph 14 says if it is not renewed, it's ipso facto the lease shall be deemed to have been terminated.
no,
So,
that's not a ground for cancellation.
oh, but
It
today,
may be a subsequent event, but that was not the list before the authority
but
cancelling.
today, if he has, at best, they can have a claim for damages. So that he can institute an arbitration or suit.
So arbitration is there, and there are provisions under the Arbitration Act also where he can seek
Yes, of
remedy.
course.
Even
Because
this honorable court
they
also
can have a
cannot
money
and
claim, they cannot hold on to the premises.
Both the parties are ready, this.
No.
court Also can.
So how can?
Why?
Now.
You avail of the
only
remedies.
Submission is.
You avail the
If, my lord does not.
Yeah, have you approached them for appointment of arbitrator
No,
in terms of clause
No.
15? Then where is the
because
occasion?
these proceedings were pending.
Your petition under 11.5 also will not be maintainable at this stage. Where is the question of writ court appointing an arbitrator?
My lord, this is,
You have to approach the lieutenant governor for appointment of arbitrator. You have not done anything.
my lord, the cancellation was not served, so-called notices are not
How
served.
many times you will say that? Said that at least 10 times by now. The point is, you know the remedy. You have to avail the remedy. If you want to avail the remedy, you will avail it. Otherwise, the
If the
court will.
cancellation is set aside, then I can go before them.
Even if the cancellation is set aside, the term has come to an end, it is not extended. So he has his claim is for damages that can be done
No,
through.
No, the prayer that he is making in view of the arbitration clause, why the writ court should exercise jurisdiction, that is the only issue. On that, you have not made any submission. So then the matter will have to be decided accordingly. If you want to avail the remedy, then
No, we will avail the remedy. Arbitration
then
remedy.
that I can, yes. The petitioner has approached this court This is in this case.
Item number 14, WPA 93 of 2024.
Yes, not today.
My lord.
Item 50,
15 also. It's not.
Yes. There is no respondent. Respondent is not appearing in.
14 we are appealing. One of the response.
In 14,
Yes, sir.
so in presence of respondent, the matter is adjourned. You give your appearance.
Mine. Most grateful.
Over.